Good morning, everyone. Welcome to today's webinar on sponsoring foreign workers in your tech business. You can download the employer guide to sponsoring foreign workers by either clicking on the link or screenshotting the QR code. Welcome today. We're really excited to have this session with you. It's our last session of the year. So we're really excited that you're part of this community. We'd like to start with acknowledgement of country. We acknowledge and pay respect to the past and present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Aurora Nation, whose land our Sydney headquarters is situated on, and the various lands on which those of you are joining us today. My name is Yin Chiew. I'm the practice leader of the corporate immigration team at LegalVision, and I will obviously be hosting today's webinar. Before we begin, you will receive a copy of the slides. They should be sent to your email. If you have any questions throughout the webinar, you can submit them in the Q&A box and we'll answer them at the end of the session. And we will be really grateful if you can complete the feedback survey after this webinar. Don't forget as well, your attendance and registration at this webinar then entitles you to a complimentary consultation. You will see that there'll be a lot of information provided today. It's meant to be quite generic and general information. It may not necessarily be specific to your circumstances. So hence the reason why, as an attendee registrant, you're able to claim a complimentary consultation where we can discuss your matter specifically. And so to claim the complimentary consultation, don't forget to submit your feedback survey as well. I want to first start by saying that I have a little bit of a cold. So I may cough, or I may need to just step away and blow my nose. Otherwise, I'm still well, and I hope that doesn't impact you. But I wanted to first tell you that, so you're not too concerned, but also let's move on to what we're going to discuss today at the webinar. The first is understanding skills and occupations in demand, and why that's quite important to determine what is the best employer-sponsored pathway. There are a few, and we will discuss that. We will discuss the new skills in demand visa. We will provide an overview of what the distinction and differentiation is between the skills in demand visa and its predecessor, the temporary skills shortage visa. We'll also have a look at the National Innovation Visa, briefly, which is not an employer-sponsored visa, but it is targeted to high caliber talent. And then alternative employer sponsorship pathways that you may want to consider. What are some tips and tricks for attracting and retaining top talent, and then a Q&A at the end of the webinar. So obviously, you'll see that there will be a lot of topics to review and discuss, and there may be a number of employer sponsorship visa options available. What would be right for your business will be very much based on your objectives, the actual nominated position, and the skills of the nominee as well. Before we actually get started or before we delve into all that, please, I encourage you to complete the poll. There's a question, why are you exploring foreign worker sponsorship for your business? And there's multiple choice questions. So if you could please complete the poll, and then we'll explore your answers towards the end of the webinar. Okay, so for technology businesses, and I'm using technology businesses as an example. This type of assessment can be done for any business, for any occupation in any industry. First, it's identifying what are some of the occupations, what are some of the skills that would align with those occupations that are in demand within the technology industry at this stage. Obviously, there'll be ICT managers, data and business analysts are also incredibly in demand, software development, programming engineers, cybersecurity as well, database and network administration. The reason why I've outlined some occupations in the technology space is this is often the first step in determining what is the best employer-sponsored pathway. Okay, and often with some Australian businesses or technology businesses, the analysis may start with the actual foreign worker or the actual employee or talent that has the relevant skills. And why it is important to actually start with what is the actual position being undertaken within the company. Why that's important is with any employee sponsorship visas, there are obviously sponsorship obligations that apply. And one of those sponsorship obligations is that the approved sponsor employer must ensure that the sponsored employee is working within the nominated occupation. So the first step is to ensure that you select the correct occupation. That then informs the most appropriate employee sponsorship pathway. And why that's important is with the new skills and demand visa, there's obviously a new occupation list, which we will explore momentarily. The skills and demand visa, fortunately, includes the majority of these technology occupations. So before we move on to the next slide, we do have the results of the poll question. So thank you very much for completing that. And I'm going to share them with you. So the question is, why are you exploring foreign worker sponsorship for your business today? First question, to fill skills gaps within my team. Obviously that's 43% of you. There is a lack of available skills in the Australian labour market. There certainly is, about 32% of you. We have been advertising for several months and can't identify an Australian worker. That's about 11% of you. We operate in a niche industry that requires specific skill set. That's 21% of you. And just exploring options, no immediate plans. So that's probably about half of you too. So appreciate your feedback and your participation in that poll question. We'll then move on to the next slide now. Some other emerging technology occupations, blockchain, artificial intelligence, obviously blockchain, cryptocurrency, AI, machine learning, all these skills are not adequately defined in an appropriate occupation that would be available on an employee-sponsored visa framework. There are other options, obviously, which I will discuss momentarily. But given the industry, given the changes and the emerging existence of these niche skills, obviously the employer-sponsored framework needs to ensure that it is flexible and adaptable. So let's determine if the new skills and demand visa does actually encompass those emerging technology skills. We'll move on to the next slide. So as I said, why it's important first to identify the relevant occupation, which will be based on the assessment of what is the position? What is the position within the business, within your technology business, or any business for that matter, that you are trying to fill? Is it an occupation that is identifiable? Is it an eligible occupation on a list for an appropriate employee-sponsored visa? And that will inform further considerations and assessment as well. So moving on to the next slide, which is obviously what many of you have joined this webinar for, is what is the new Skills in Demand visa? The Skills in Demand visa was introduced on the 7th of December, and it effectively replaced its predecessor, the Temporary Skills Shortage visa. Although the actual subclass, you could say, of the visa, subclass 482, remains. And its purpose is still to attract skilled overseas workers to fill critical talent shortages in Australia. There is a new occupation list. There is a different criteria, requirement, and framework, although it very much encompasses the essence of the TSS visa framework, although its objective is to allow for more streamlined processing of key occupations or core occupations, and then highly specialized skills and occupations. So let's have a look into it in depth. What does it involve? What is the criteria? Is it an option your business can consider? In most cases, it probably will be, but it will be a determination of whether the business and then the nominee can meet the criteria, what stream is relevant, and then what the costs are for the business. So what's the comparison? In terms of the visa stream and sponsorship periods, there is actually 2 streams of the SID visa. There's actually 3, and there could potentially be another one. But what has been introduced from 7th of December is a core skills stream, whereby the occupation must be on the core skills occupation list, and the minimum income threshold or salary needs to be at least 73,150. Okay. For the specialist skills stream, there is no occupation list, but the occupations do need to be an occupation in major group 1, 2, 4, 5, and 6 of the ANZCO directory. Then it needs to meet the income threshold of at least 135,000. If the occupation for the specialist skills stream is also on the core skills occupation list, and caveats, this is additional criteria that the Australian business would have to meet, applies, then those caveats need to be satisfied as well. There's also an expansive period of sponsorship available now, meaning that regardless of the stream, regardless of the occupation, the business is able to sponsor an eligible worker on a SID 482 visa from anywhere from 1 to 4 years. Okay, and there will be permanent residency pathways available for SID 482 visa holders in either stream as well. Usually it will be after a 2-year period, but in some instances it can be sooner as well. There are slight changes to other criteria such as work experience requirement. Under the TSS, it used to be 2 years of work experience. Under the SID 482, it's now 1 year of work experience obtained in the last 5 years. And then English language requirements have also been updated as well. Okay, so in a way, in an analysis of why the SID may be more beneficial to the TSS is that there was obviously a lot more restrictive streams, and some streams under the TSS framework did not allow for permanent residency as well. So moving on to the next slide. So let's talk about the National Innovation Visa, which was also introduced on the 7th of December and effectively replaced the Global Talent Visa. It's still the same subclass, the name has changed. And the criteria is predominantly the same, except for the fact that there are a few changes to the requirements. And we'll talk about that momentarily. But the National Innovation Visa has always, and its predecessor, the Global Talent Visa, was always designed to attract high caliber talent. So the National Innovation Visa, as with the Global Talent Visa, is not an employer-sponsored visa. It is a direct pathway to permanent residency. It is an invitation-only visa. It typically will require a nomination by an Australian citizen or permanent resident There are additional criteria for Australian nominators as well now under the National Innovation Visa. Its target audience or who it hopes to attract can be anywhere from successful tech entrepreneurs with proven track records. It can be researchers in advanced fields. I'm sorry. I'm just going to take a moment to cough. Thank you everyone for your patience. Coughing in front of a live audience is not fun. Luckily, it's online and you don't have to be close to me. So it can be any type of individual that may be considered high caliber. And now the definition of that has been more finely tuned, and we'll talk about that in the next slide. So what's involved and how does the Department of Home Affairs assess high caliber talent for the National Innovation Visa? Well, first, they consider if the high caliber talent or the prospective applicant meets one of the priority sectors, okay? There are what's called priority 1 to 4 categories. And they are defined as priority 1 category candidates as exceptional candidates from any sector who are global experts and recipients of international top of the field awards. Now, the Department of Home Affairs provides examples of what will be considered international top of the field awards. And they're things that we would know or be aware of, such as Nobel Prizes, such as President's Awards, such as some international award that is well known across the international community. Priority 2 are candidates from any sector nominated specifically by an expert Australian government agency using the Approved Form 1000. So with the National Innovation Visa, it is an invitation only. Applicants do need to submit what's called an expression of interest first. If they are invited to apply, then they will receive an invitation. They can then apply for the actual visa. But in their expression of interest, they need to identify an appropriate Australian nominator and it can be an Australian citizen or permanent resident, but for priority 2 candidates, okay, if they are to be priority processed in that fashion, then that approved nominator needs to be an expert Australian government agency. Then we have priority 3 and priority 4 candidates. Priority 3 candidates are those that have exceptional and outstanding achievements in tier 1 sectors, critical technologies, health industries, renewables, and low emission technologies. And then candidates in priority 4 with what is considered exceptional and outstanding achievements in tier 2 sectors, agri-food, ag tech, defense, capability, space, education, financial services, okay? So you can see already there is a distinction between the types of candidates that the Department of Home Affairs will consider. And obviously there is a categorization of priority in relation to them as well. This is a very competitive process, which means that there is no guarantees that an applicant will receive an invitation, even if they're assessed, even if they're of the view that they are of a high caliber talent and meet one of the priority sectors. It really will be based on a discretionary assessment by the Department of Home Affairs. And as we move on to the next slide, I will also pause for a moment to cough and also take a sip of water. Thank you so much for your patience. Thank you, everyone. So what are the key features of the National Innovation Visa? Well, it's a pathway, direct pathway to permanent residency, but it's highly, highly competitive. And when we're looking at priority 1 and priority 2 candidates, we're really looking at the top echelons of the field. These are candidates where they would probably be internationally known, even to the layman as well. Then the majority of candidates may be in the category 3 and 4 sectors, where they can demonstrate to the requisite standard exceptional achievements and international recognition in a tier 1 or tier 2 priority sector. Okay, but the focus of the National Innovation Visa obviously is to ensure that whoever is being invited to apply for this visa and subsequently being granted permanent residency is there to advance Australia's economy in whatever industry or achievements or recognition that they're known for. Okay, so that's always been a core requirement of the Global Talent Visa and now the National Innovation Visa as well. Let's move on to the next slide. So if the Skills in Demand visa is not an option, or if the occupation is not an eligible occupation under the specialist skills stream, under the core skills stream, then it may be something for the business to consider in terms of a labour agreement. So what that means is a labour agreement is a tripartite agreement between the Australian business and the Australian government and the Minister for Home Affairs. And it does allow the Australian business to sponsor certain workers under that sponsorship framework. So it's quite a unique process, and there are a number of different types of labour agreements available, and it's typically requested when the standard employer-sponsored pathway is not available to your technology business. And that might be the case, and that might be the case for many businesses as well. There are a range of labour agreements. There are company-specific labour agreements. These are labour agreements where they're specifically tailored to the individual business. Excuse me, 1 second. I'm so sorry that I've had to pause a couple of times while I cough. It's most annoying. But thank you for your patience. I appreciate it. There are industry labour agreements that are specific to certain sectors, and there are designated area migration agreements that are available to Australian businesses within a specific regional catchment area as well. Usually under the labour agreement, certain occupations can be negotiated, meaning that it could be an occupation that's not on the standard employer-sponsored list. It could be an occupation that is designed by the business. That's certainly the case under company-specific labour agreements. You could be after specific concessions, such as age exemptions or alternative age limits or English language thresholds or income concessions as well. So a labour agreement is quite important when the standard pathway is not available, when you have unique needs or the occupation is specifically niche or tailored to your business, or you're in a regional area and you're looking to locate certain workers and you require certain concessions as well. So let's move on to the next slide. There's obviously a regional employer-sponsored visa, which is called the subclass 494. Now, nothing has changed here. This remains the same and is available for any Australian business that operates within a designated regional area. There's a list of postcodes as well. The 494 visa does have its own occupation list, which is not the same as the Skills in Demand visa. It's also a longer term visa, meaning that when it's granted for a period of 5 years. There are very strict conditions that apply to the visa as well, because obviously the goal of it is to assist regional businesses as well. Let's move on to the next slide. And this is just a bit more information about the subclass 494 visa. I have some questions. I'm happy to answer that at the end if that's okay. But I will get back to that. Thank you so much. There will be pathways to permanent residency that's independent of employer sponsorship as well. So the 494 is a regional employer-sponsored visa, and it does require the applicant or the employee to work in the designated regional area for a specific period of time before they're able to access permanent residency. And that's obviously to support that regional Australian business to retain that skilled worker. So let's move on to the next slide. I might answer this question, and then there'll be other questions that I can answer. The question is, does SID, the Skills in Demand Visa, have a specific labour agreement such as CSLI and DARMA? Yes, so the Skills in Demand Visa subclass 482 will be used under any of the labour agreements. It is, and then also under a DARMA as well. It's quite interesting how it's done, in that its predecessor was called the Temporary Skills Shortage Visa. It's still the same subclass. It will still be used as a mechanism for businesses that need to request a DARMA or a labour agreement as well. It will just be specific terms, criteria under the actual applicable labour agreement. Okay, so what are some tips to attract top talent? The first is identify what is the talent and the skills that you need. Do you need to actually partner with a reputable recruitment agency to do that? If you want to, obviously, at LegalVision, as a law firm, we typically only provide the legal advice around the visa options and the immigration framework. Having said that, we have a number of partnerships with global recruitment organizations where they have expertise in sourcing, recruiting, identifying the correct talent for your business. So if you're looking at organizing a consultation, a complimentary consultation with me later, I can certainly discuss that with you. Obviously, consider how the position and your business will have a unique value proposition for that top talent. Do you allow for remote work options? Do you include, or do you emphasize diversity and inclusion as well? Maybe partner with certain organizations where you're able to identify top talent as soon as they graduate as well. So a lot of opportunities and tips to attract top talent as well. And certainly from LegalVision's point of view, we'll be there to assist you with the immigration compliance perspectives. Okay, I'm just looking at some of the questions. And before we get onto that, there is a guide for you to download. And you can just scan the QR code. I will warn you, the guide is a little bit outdated at this stage, given the introduction of the Skills in Demand Visa. Obviously, given that it was only introduced on the 7th of December, we will ensure that this guide is updated and then circulate that accordingly as well. So thank you for your patience. So next is, please join us for our next webinar. If you enjoyed this webinar, if you enjoyed our previous webinar, if you're part of our webinar community, then please join the next one, which is Preparing Your Business for Success in 2025. Very important topic, and also a very good start to the year as well. That will be on Thursday, the 6th of February at 11 a.m. Australian Eastern Daylight Savings Time. You can register your interest at the link on this slide. So I'm just giving everyone the opportunity to submit any questions. There have been questions that were submitted prior to the webinar, and I will do my best to answer. Some questions may require a complimentary consultation where we would have to discuss that specifically and unique to your business. So please feel free to claim that complimentary consultation, but also submitting your feedback survey. But before we go through the questions and answers, and to give you time to type in your questions, I'd like to tell you about how you can become a LegalVision member and how you can gain access to 100+ experienced lawyers across all our practice areas, which includes immigration, which includes employment, litigation, commercial contracts, corporate transactions, tax, and a whole much more as well. And how that membership will help you to gain access to unlimited advice consultations, unlimited document drafting and reviews, quick turnaround times, but more around the affordability and cost certainty of your legal services as well. Okay, so again, please submit your feedback survey, download the publication, submit your questions now. I'm going to answer them, and please claim your complimentary consultation. All right, so I'm going to look at the questions. And again, I apologize, I'm going to take a sip of water so I don't cough too much. The question is, for National Innovation Visa Priority 2, the approved nominator must be an expert Australian government agency. Who are the examples of experts in this case, and what is the process to get nominated? I don't have the list, unfortunately, but it will be dependent on the actual candidate and what is their field of expertise, and whether there is a corresponding Australian government agency that has expertise in that same field. Okay, so there is no one list and no one size fits all. How do you then, upon that assessment, how do you then go and get nominated? You need to approach that Australian government agency, whether the actual talent, the candidate does that, or whoever is representing that client as well. Next question. Let's say the employer gets their PR after 2 years. Will those years count towards their citizenship requirements, or will they need to start fresh? They will count. What happened to the essential skills pathway and skills in demand? It's yet to be determined. What we understand in the industry and what has been indicated by the Department of Home Affairs is that the essential skills stream will be implemented. When that will be implemented and what that involves is not information that I know right now. I guess we'll all have to wait and see. Can a visa be issued, for example, 5 years, but specifically not lead to residency? It depends on the visa. If we're talking about a 494 visa, that is automatically granted for 5 years. And yes, it doesn't have to lead to permanent residency. Permanent residency is typically a separate application, a separate stage. How long does it take from when we start application until the work visa is issued? It depends on a lot of different variables, how long it takes to prepare the application, how many applications are involved, whether labour market testing is required. Then once it's actually lodged, it will be based on the department's indicative processing timeframe. Okay, there's previous questions before, so I'm just seeing if my colleague can pull that up for me to answer, or if there's any more questions. Let's see, here we go. What are the associated costs to sponsor from staff and potential risks involved, possible timeframes to hire? It's a difficult question because it will depend on how many applications are involved. Generally, approximate range is anywhere from 6,000 to 15,000 totality. There'll be some costs that the employer sponsor must cover, and there'll be costs that the applicant can cover as well. There's a lot of variables here, so I can't provide an exact cost. What are the potential risks? The risks are always if you obviously spend that time recruiting that worker, find that talent, offer them employment, pay for the cost for them to sponsor them. They migrate here, you may pay for relocation costs. The risk is that they don't start or they don't stay with the business, and you've obviously expended that amount of money. So we obviously advise that there'll be costs that the business must cover, and there are costs that the employee can cover, and to make that available. Can you help with foreign staff for home services, not just technology? Yes, absolutely. We assist businesses specifically for immigration, employer-sponsored visas, and compliance for any worker and in any industry. We do partner with a recruitment company that does offer recruitment services for professionals in technology, healthcare, and construction. So if you want to organize a complimentary consultation with me, I can certainly make those introductions. How do I remote hire employees abroad? You can, and it is more of an employment law question rather than an immigration question, but it is possible to do that. Is getting working visa for overseas workers hard and taking a long time? In my professional view, it's always been a process with employer-sponsored visas. It's not a simple experience, but it certainly is a process, but a process that can be navigated with a professional and an expert as well. Is it taking a long time? There will obviously be some occupations that will be prioritized over others, but the objective of the skills in demand visa is that if they are identified under the specialist skills stream, the core skills stream, they are to be processed quickly, and it's to ensure streamlined processing. Just general interest to hire directly. I would normally use a third party to hire overseas, no problem. Legalities for Australians hiring outside employees. Excuse me, I'll just take a sip of that. That really depends on the situation. So if the employee is going to be based offshore, will that be employment law and immigration law implications? Probably not so much. More employment law implications. If they're going to be based in Australia, there's a lot of employment law and immigration implications. Looking forward to understanding the basics about Australian employment laws. Sorry, I'm just trying to read through the questions properly as they keep moving a bit. So looking forward to understand the basics about Australian employment laws, do's, don'ts, immigration, BV checks. I would suggest booking in a complimentary consultation first. That sounds like a lot of questions there that we'll be more than happy to answer. Types of visas available based on full-time commitment or short-term. That there's a variety. And again, I would encourage you to book in a complimentary consultation, because that can be an expansive list, or that can be a more narrower list based on the assessment of the business's specific circumstances and needs. What about hiring foreign workers to work here locally? Well, there are a number of options which we discussed today in the webinar, but again, to tailor that advice and that strategy to your technology business, or to any business for that matter, we usually start with a complimentary consultation to assess your needs. What is the difference between the 482 and the new skills in demand visa? Well, it's still the same subclass visa, 482, but it's now called the Skills in Demand visa. Previously, it was called the Temporary Skills Shortage visa. Who can sponsor an employee from overseas? What if the employee is Kiwi? Any business really can sponsor an employee from overseas, provided that they meet the criteria of the relevant employer-sponsored visa framework. Kiwi employees, well, if they're a New Zealand citizen, they typically don't require sponsorship. That can work in Australia. Okay, let me just see if there's any more questions. And thank you so much for your wonderful questions and participation. Do you provide EOR service? We don't. I'm assuming you're referring to employment offshore services. LegalVision is a commercial law firm, so we don't directly do that, but we will certainly have businesses, partners that we work with that do offer those services. So again, if you want to schedule in a complimentary consultation, we can certainly make introductions to our partnership networks as well. Okay, what do you think about the HR doing the process of the 186 fees instead of using a lawyer? As the lawyer fees are pricey for our small businesses, we already have the employees working with us. In my experience, that is always up to the business. Sometimes some businesses feel confident enough to do it. From what I have, from the feedback provided from clients, they often don't know what they're doing. They often don't realize what the requirements are, and they often find the experience incredibly lengthy and time consuming as well. And they often don't understand the request for further information required from the Department of Home Affairs. So it's going to be up to your business. You might say, well, we don't have the cost to engage a lawyer to prepare these applications for us. But if we don't get it right and we don't understand the process and we don't provide the key documentation and that visa is refused, then that's more costly to us than doing it right from the beginning as well. And so we as lawyers take a risk-averse approach, and what we obviously advise clients from a commercial perspective too. But totally appreciate the limitations, absolutely. So again, claim your complimentary consultation. Thank you for participating and joining this webinar. Please complete our feedback survey as well. I want to wish everyone a wonderful Christmas, a new year. We can't wait to see you in 2025 as well. I look forward to talking to you, and I look forward to assisting you going forward as well. Thank you everyone for your time.